Got a question on TikTok about if a tenant decides to leave an abandoned vehicle on a single family home property while the tenant is still, residing at the property, can a landlord have it towed away? Hi, my name is Rob Wells. I'm the landlord. We're on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, the answer to that question is generally no. A landlord in this case, if they're a owner of a single family home, they cannot tow the tenant's vehicle off that property. The reason why that is the case is under Vehicle Code Section 22658A. The code basically says it's the owner or the person in lawful possession of private property, meaning if you as a landlord rent a single family home out to a tenant, basically, who has possession, the tenant would have possession. So they would be the one authorized to have vehicles towed and so forth like that. So, and I actually had this happen. I heard of a landlord having this issue before, and in fact, it caused an armed confrontation with the tow truck driver and the tenant, and landlord thought they were doing everything right and so forth. I think it was like expired tags or something like that. They're going to have the vehicle towed off the tenant's driveway, and that there was no winnable case on that one whatsoever because the landlord was completely wrong. The solution to that issue, probably if the lease had a provision about having an abandoned vehicle on property, it's inoperable, that type of deal, would be to enforce your lease agreement through a 3-day notice to perform, warning your tenant, hey, listen, you have an abandoned vehicle on the property here. Per the lease, you can't have that. That would probably be a material breach of lease term that a court would enforce, because in a lot of municipalities, including in the area that I'm in, it's a violation to have an inoperable vehicle sitting outside in public view. Basically, they consider that a public nuisance, and you could be cited by code enforcement for that. Other issues, if it was, I've heard some landlords wanting to tow tenant vehicles for like expired tags. I'm gonna be honest with you, that A, you're not gonna be able to tow it if it's on a single family home. B, it's probably, even if you did a 3-day notice to perform, it's probably an immaterial lease violation. Okay, it's trivial. Court won't enforce or allow you to evict the tenant just for that, even if it's in the lease. There's some violations that are material, there's others, the rest are immaterial. Okay, a little bit different story if you are in an apartment complex or like condominium complex where the tenant doesn't have exclusive possession of the parking lot. If you have appropriate signage and the car is parked in an unlawful fashion, you might be able to tow per the vehicle code, but that's a different video for a different day. Okay, so you got to be careful about when you tow vehicles and whatnot, because the vehicle code is very specific on this issue. So if you have any questions about that or you're not sure, it's always best to consult with local counsel to make sure your attorney, basically, to make sure, hey, you're doing everything on the up and up, okay? Or if you can enforce that through a 3-day notice to perform. Folks, if you're in the Northern California area and you're having parking issues with your tenant and you might need some help, feel free to reach out. We might be able to help out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.